Are we live? Bye-bye. Who's that? Huh? Can't stand. Somebody's been studying real hard, and he's hungry. Love bug. What's up here, love bug? What's up here? Oh, that's how you do that. So, I'm actually going to read professional responsibility note cards off the wall. So that's why where the computer is, it's not so important right now. It's going to be kind of loud. So, what is the we're going to start with client decisions. So these belong to the client. Hiring a lawyer, settlement offers, pleas, waiving a jury trial, testifying in a criminal case, and deciding to appeal. There's a couple of other terms to consider as you write an essay, like for issue spotting reasons. Consider that a lawyer may not assist a non-lawyer in the unauthorized practice of law. And there's some marketing concerns. The lawyer as the negotiator, the lawyer as the advisor, the lawyer as the third-party neutral, the prosecutor's special duties, safeguarding. Lawyer is subject to discipline for misappropriating or borrowing a client's money or property. This here says the client agrees to a proposed course of conduct after the lawyer has sufficiently explained the material risks and reasonable alternatives. That probably has to do with what we talked about initially. Informed consent actually is what that's called. There's fee sharing. I probably don't have a note card on fee sharing, which may be done with among lawyers, but not a non-lawyer unless the money is a death benefit payable under an agreement between the deceased lawyer and his firm, or the purchase price for the sale of a deceased, disabled, or disappeared lawyer's practice, or into a retirement and compensation plan for firm employees that aren't lawyers, or to a nonprofit organization that hired or recommended a lawyer. If none of the circumstances are the case, the fee may not be shared with a non-lawyer. On the other hand, a lawyer may share the fee with another lawyer, partner, or associate from their practice, or a lawyer that is a former partner or associate, and the sharing pursuant to a separation or retirement agreement, or if the following conditions are met, the share is proportional to the services performed by the lawyer, and or in any other proportion if each lawyer assumes joint responsibility, the client consents to the split in writing, and the total fee is reasonable. What's the matter? Still eating? I'm gonna be freaked out by his own reflection. Um, so you need the client to consent to the split in writing, and the total fee is reasonable, it's proportional, the service is performed by the lawyer, um, or the lawyer assumes joint responsibility. Lawyer's representation of current clients with conflicting interests. There's a decision tree that I've never really looked at before. Um, it works its way down in like directly adverse representation where the clients are opposing one another in the action, like the matter, the same matter, and or less directly adverse is whether the clients are co-parties on the same side in the action but with conflicting interests or the potential to have conflicting interests. And then if the representation requires the lawyer to represent a client in one case and oppose that same client in the simultaneous pending case, he may take that case, he may accept that conflict if a disinterested lawyer would conclude that the client should not agree to the representation. So the lawyer reasonably believe that the relationship will not affect his relationship with the other client, and the lawyer has given informed consent confirmed in writing to the representation. So under those circumstances, you can represent a client in one case and oppose that same client in a simultaneously pending case. And lastly, would the representation require the lawyer to take inconsistent legal positions, argue on behalf of client one that law is unconstitutional, and argue in a separate case on behalf of client two that the same law is constitutional? If you're taking separate positions like that, generally that would be a problem, but it can be overcome if a disinterested lawyer would conclude that the client should not agree, so the opposite inverse could agree to the representation. Secondarily, the lawyer reasonably believes that the representation will not affect his relationship with the other client, and each client has given informed consent confirmed in writing to the representation. Then the lawyer may undertake the representation, notwithstanding the conflict. Attorney-client privilege is confidential communications protected against compelled testimony, including conversations between the attorney and client, letters and other documents between the attorney and client. The duty of confidentiality pertains to all information relating to representation of client, protected from voluntary disclosure and from use harmful to the client, which includes attorney-client privilege conversations, and also communications between the attorney and the client with a third party present, communications made when the client seeks attorney services in the future, crime or fraud, and the information concerning past frauds involving attorney services, mechanical details of attorney-client relationship, fee arrangement, client identity, and relevant pre-existing documents and things. So all of those fall outside, like all of those 1, 2, 3, 4, 5 types of information fall outside of the attorney-client privilege that would be protected against compelled testimony. So you can be compelled to speak or you can be compelled to disclose communications with third party present, or when the client sought services for future crime fraud, or reported having used legal advice for past frauds, mechanical details such as how much you're charging a client and relevant pre-existing documents and things. And then all the things that are outside of these two circles is basically not protected by the duty of confidentiality. That's information required to be disclosed by law or court order, information necessary to detect or resolve conflicts of interest, information necessary for the lawyer to obtain legal ethics advice, only under the model rules, not California, and then information for which disclosure expressly or impliedly authorized by the client, information necessary to prevent reasonably certain death or substantial bodily harm, client communications revealing intent to commit future crime or fraud reasonably certain to result in substantial financial harm if lawyer services are used, or to prevent or mitigate financial harm if the client has already acted. So that's only a bar in the model rules. California, that would be protected under the duty of confidentiality. It would only be disclosable that a future crime was reasonably certain to result in death or substantial bodily harm. And then information, lastly, relevant to a dispute involving the attorney's conduct, such as a fee dispute, malpractice, or misconduct charges. So, under what circumstances can an attorney take a financial interest? What's the right way of saying that? Balance their own financial interest. Oh no, I'm sorry. Engage in a business transaction with a client. Under what circumstances can that occur is whether the terms are fair to the client, if the terms are fully disclosed, these are essential terms in writing, if the lawyer's role in the transaction probably is one of those essential terms. The client is advised to seek advice from an independent lawyer regarding the arrangement in writing, and the client is given time to seek advice and provide their consent confirmed in writing. In California, I think the consent also has to be in writing. Analyze facts. Is it legal? So this goes back to conflict of interest. Analyzing the facts. Is it legal? Can the attorney effectively represent both clients? Disclose potential if so, disclose the potential conflict, and the client provides informed consent confirmed in writing. If the potential for conflict ripens into actual conflict, attorney must withdraw from at least one party if the other provides informed consent confirmed in writing. California rules of professional conduct require a written fee agreement if the fee exceeds $1,000 unless the client's a corporation. The client states in writing she doesn't want a written fee agreement. Legal services are the same kind of services that the client has previously received and paid for. It's an emergency or it will be impracticable for other reasons. Under the model rules, what does it do with contingency? Okay, contingency fee agreements are a little different. Under the model rules, these need to be signed by the client, speak to the allocation of expenses, the scope of representation must be outlined. It needs to be signed by both the attorney and the client. A copy needs to be rendered. And in California, there's just a little bit more. So I'll read the same thing. Okay. So under the model rules, actually, the writing, they both require writing, but the writing needs to be signed by the client under the model rules, but in California, it needs to be signed by both the attorney and the client. And the lawyer collects the fee only if the matter is resolved in the client's favor. That's what a contingency fee is. So that's not really, that's foundational to both the model rules and California rules of professional conduct. So I guess the model rules don't require that you render a copy, but the California Rules of Professional Conduct do. The Rules of Professional Conduct also require that the scope of representation is outlined and that the expenses are allocated. And also need to say that the percentage is negotiable in California. I don't know why that's not written on my note card, but I suppose this is like kind of a dual note card for two different rules of law, which is probably not the best way to do this. So contingency fee is when a lawyer collects a fee only if the matter is resolved in the client's favor, and often is expressed as a percentage of the client's eventual recovery. And some states set statutory limits on that percentage. Moving on, involving the same transaction, a legal dispute otherwise is a substantial risk that confidential factual information as something normally have been obtained in prior representation would materially advance the new client's position. So that's kind of probably when you have a conflict with a prior client. Let's see what's on the back here. Okay, trial publicity is you can engage in this to clarify prejudicial remarks made by the opposing attorney. Okay, so exculpatory evidence that the prosecutor has to give must be, quote, new, credible, and relevant. Come back here. Key factors. Okay, these can't be unconscionable in California. In the rest of the country, reasonable by community standards. What else does this say? Oh my god. The complexity is relevant to the fee. The preclusion from other employment, experience, expertise, reputation, actual work, and outcome achieved and in California, all of those same things are relevant to the fee. It also includes time and skill and relative sophistication. A lawyer may waive fees for an indigent and advance expenses of litigation without repayment if indigent makes arrangements for repayment of advanced costs. Release and settling claims / waiving malpractice claims, i.e. holding harmless. In the ABA model rules, it's permitted if advice and consent from an independent counsel retained for the release, but in California, it's strictly prohibited. All right, so move on to like 15 more definitions here before we come back to my desk. So, what is diligence? I didn't read the rest of safeguarding. Safeguarding, a lawyer is subject to discipline for misappropriating or borrowing a client's money or property or commingling it. Attorney is expected to maintain a client trust fund. Diligence. Once a lawyer takes on a client's matter, he or she must act on the client's behalf with reasonable diligence and promptness to act with dedication and zeal to vindicate the case in all steps. Third, pursue the matter to completion unless fired or withdrawn. And fourth, terminate if there is a doubt as to the lawyer-client relationship. Candor to the tribunal. I've written in the parentheses here, chicanery, truthfulness, expect the same level. Something, advocates. So an attorney may be subject to discipline for law, knowingly making a false statement of law to the court, in failure to correct material false statements, failing to disclose directly adverse law of controlling jurisdiction, also discipline for facts and evidence. So evidence will be offering false evidence. As far as facts go, it looks like it's twofold. Knowingly making a false statement of fact or failing to correct a false statement in on maybe detection if material, and part two, failing to volunteer known material facts in ex parte proceedings. Client, a lawyer shall abide by a client's decision to settle a plea, waive jury trial, testify, terminate attorney, consult on means by which the client wants. All those things I stated at the beginning. Competence. In representing a client, a lawyer must act competently and with the legal knowledge and skills, thoroughness, and preparation that are reasonably necessary to the representation. Preparation, okay, that are reasonably necessary to the representation. Confidentiality. Confidential information learned through the council of representation. The course of representation. The attorney has a duty only to keep confidential information learned during the course of representation. Attorney-client privilege protects confidential communications between a lawyer and a prospective client. A lawyer must not reveal or use information learned during consultations unless an exception to the duty of confidentiality applies. Conflict. Prospective clients. A lawyer who obtains confidential information during the consult must not later represent another with the same or substantially related matter if use of confidential information would significantly harm the prospective client, and this includes to the firm. For former clients, the duty is continuing, may not be used to disadvantage a party, bars an attorney from representing a client with adverse interest in substantially related matter unless informed consent confirmed in writing. Consent. Informed consent confirmed in writing in California from the affected client and the prospective client is okay. A, B, and C. A. Avoid exposure to any more confidential information than is necessary to identify the conflict, like the client, the represented client. And B, demonstrate disqualified lawyer is timely screened from any part in the matter and is receiving no fee. And third, written notice to prospective client of both the first A and B that I just gave, that I just read. Now, contingency fee requires a writing signed by the client. It includes a method by which fee is to be determined, a percentage of the settlement, trial, or appeal. Expenses, you must include, and it's weird I didn't have this on the note card, but you must include what the expenses are deducted before or after the contingency is calculated, and the cost client is responsible for whether or not he prevails. I'm about to take this card off the wall because it's so deficient. All right. Loyalty to the organization. The lawyer owes a duty of loyalty to an organization, not to the people, like the stakeholders, or the directors and officers. Under ABA rules, a lawyer may undertake representation of one the lawyer reasonably believes he can competently and diligently represent each affected client, dispute the cause of conflict of interest. 2, the representation is prohibited by law. 3, the representation does not involve asserting a claim by one client against another client represented by the lawyer in the same proceeding. And 4, each affected client gives informed consent confirmed in writing, or in California, disclosure and consent must be in writing. Professional misconduct, attempt to violate disciplinary rule, assist or induce another to violate a rule. Criminal conduct that is dishonest shows dishonesty, unfit for practice of law. Engaging in conduct prejudicial to the administration of justice, implying improper influence of an official, knowingly assisting judge in the illegal act, engagement in discriminatory harassment or leading to practice of law, due care, owed by attorney to client, any third party exceeding in errors of judgment, exceeding mere errors of judgment, failure to conduct reasonably competent legal research, standards, research techniques, exercise by prudent attorney to find an answer to a legal question. So that's due care. Owed by attorney to a client or any third party, exceeding mere errors of judgment, failure to conduct reasonably competent legal research, for example. And then I described what that was. So now we're going to go into confidentiality again. Prohibited representation, business transactions, meritorious claims, and contentions only. Permissive withdrawal, mandatory withdrawal, and communication. Confidentiality. Parent client. A lawyer must not use the client's confidential information to the client's disadvantage or to benefit the lawyer or someone else unless informed consent, or some other exception. Fraud. Representation. Oh, what's prohibited is representation directly adverse. Significant risk that representation of one client will be materially limited by the lawyer's own interest or responsibilities to other clients, former clients, or third persons. And business transactions are a lawyer must not enter into business transaction with a client or knowingly acquire an ownership, possessory, security, or monetary interest. I think in the subject of the lawsuit. Whoa. That is adverse to a client unless all conditions below met, which are that the terms are fair to the client and which interest is acquired, fully disclosed in writing all under. I guess I said over here, all essential terms in an understandable manner, advise in writing to consult an independent lawyer about the arrangement, and informed consent confirmed in writing. So the acronym for that is first discussed over coffee. So fair, full disclosure, outside counsel, and cost is confirmed in writing. Informed consent confirmed in writing. And meritorious claims. A lawyer is subject to discipline for bringing frivolous proceeding and for asserting a frivolous position in the defense of the proceeding. A frivolous position is one that cannot be supported by a good faith argument under existing law or to defend the law or to change the law. Permissive withdrawal, client persists in criminal fraudulent conduct, client has used attorney services to commit past crime or fraud, objective is repugnant or against the lawyer's beliefs, client breaks promise to attorney, representation imposes a great financial burden on the attorney, the client will not cooperate, or other good cause. Mandatory withdrawal is when there's a mental or physical condition of the attorney that would make it unreasonable to continue. Continued representation would require the attorney to violate law or disciplinary rule. For example, client seeks attorney service or assistance to perpetuate a crime or fraud, and directly adverse representation with a current or former client in substantially related matter. Communication. A lawyer must promptly inform a client of any decision that requires client's informed consent. Keep client reasonably informed about and apprised about the status of the matter and means to be used to accomplish client's objectives. Respond promptly to requests for information. Consult with client who expects the lawyer to do illegal and ethical conduct or act. Exception to withhold information. So now that we've read all that, we can read the recently written note cards with Bubba. Oh, there's kind of a lot. Okay, Bob, read the note cards. Gonna read some note cards. So this one is mental or physical condition impairs representation. Client asks the lawyer to do legal work that would violate the ethical rules, and action requires that the lawyer has fundamental disagreement. The lawyer is discharged or crime fraud exception. And lastly, withdrawal if there is no materially adverse effect. All right, that's constitutional. Attorney must provide competent representation to a client and must act with diligence and must promptly inform the client about representation. That's competence. Without informed consent, confirmed in writing from each client, a lawyer shall not represent two clients directly adverse to another client. Risk that lawyer's representation of one client will materially limit the lawyer's relationship with another or lawyer's own interest. And that's a conflict of interest, and there's a 4-part analysis that follows that. Okay, this is constitutional. This is constitutional. Constitutional test, constitutional. Okay, does not authorize lawyer to reveal confidential information unless it comports with the one exception to prevent a criminal act that the lawyer reasonably believes is likely to result in death or significant bodily injury. So that's the California confidentiality standard. Lawyer retained by an organization represents the organization if the lawyer knows that a person associated with the organization is engaged in action that is a violation of law that might reasonably be imputed to the organization, then the lawyer proceeds in the best interest of the organization. Refer the matter to the highest authority that can act within on behalf of the organization. And 2, if they won't correct the violation, the lawyer may reveal information related to the violation in according to the ABA confidentiality standard. But in California, you just need to withdraw unless like a federal law requires you to disclose, such as like SEC.
Lawyers shall not bring proceeding unless there is a basis in law and fact and it is not frivolous. So those are the last of the note cards relating to professional responsibility that I'm trying to memorize.